So good afternoon. Welcome to this webinar on insolvency, and part of the webinar we're going to talk about various things, but also hopefully how you might want to deal with it if and when it happens. We are Archer. We're a specialist niche construction law firm, if you don't know. Our speakers today are me. I'm the senior partner, but don't read too much into that. Some of you will have seen me before, and we've got Sarah Lester with us, senior associate. Also, we have Nick Kuzak, who is I don't know if you can see Nick's face. Hopefully you still can. He is a licensed IP practitioner with Parker Andrews. He is just going to give us a slightly different twist on the whole insolvency thing, because he comes at it from the side of being an insolvency practitioner and therefore dealing with the effects of a party going into insolvency. So it gives you a slightly different steer. If I just move on to my first slide. So what I just want to do is highlight what's going on in the market. Now, the names that are about to come up, and here's the first one: Midgroup, then Tollent, then Metnor, Castle Oak, Midas, WRW are all contractors that we've had on the other side of developments who have gone into insolvency in the last 12 months. To put some sort of numbers to it, WRW had a turnover of 64 million. They were stated to owe over 30 million to creditors when they went into insolvency. Again, whether, that's what the figures say. Midgroup were allegedly hadn't paid subcontractors for over 5 months. Now, this is just a sort of sample of names that you may or may not have heard of. The bigger issue really is which one's next, because you want to make sure that if there is an insolvent party within your contractual matrix, you're doing the right thing. And the purpose of this talk really is to try and get you to better understand insolvency, because there are some misunderstandings around the basics of what it is and what the terminology is, and also what you can be doing contractually. So the basics. Insolvency, and particularly the construction industry, is responsible for the highest number of new company insolvencies compared to any other industry. It always is. Nick will come on to this, but it's typically the sector that shows whether the economy is doing badly or not. The issue with an insolvency is it can have a massive knock-on effect if you are overexposed to a company that goes into insolvency. And you see it all the time with Joe Blogg's contractor going bust, and all of a sudden he owes £800,000 to a scaffolder. And you do scratch your head and say, how did the scaffolder allow themselves to get into that position where they were so dependent on that one party? So, that's fundamentally why you need to understand, what insolvency is all about. Insolvency, or the definition of insolvency, is a bit like practical completion, in that it's not really strictly defined. You just sort of know it when it's there. The underlying principle is that a party is insolvent if it's unable to pay its debts. Section 123 of the Insolvency Act lists 4 possible bases upon which someone could be declared insolvent. So if you fail to satisfy a statutory demand, you fail to satisfy a county court judgment. The 4th one is liabilities exceed assets. I'll come on to that in a moment. And the 3rd one, which is the basic test, is whether someone is able to pay their debts. The 4th one about liabilities and assets, most construction companies, if we're being brutally honest, would often satisfy that test in that they have a lot more liabilities than they do assets. But the truth is, if they can still keep paying, no one does much about it. And so in practice, a construction insolvency is driven by cash flow insolvency rather than balance sheet insolvency, as it's known. Now, you may have heard the expression that the lifeblood of the construction industry is cash flow, and it actually comes from this case, Gilbert Ash and Modern Engineering. Lord Denning, who you may have heard of, a well-known judge, made this statement. I don't necessarily think you need to read the whole thing. Within the middle, it talks about it is the very lifeblood of the enterprise. So that is where that expression comes from. Perhaps the most telling thing is the last sentence. the employer must pay the main contractor must pay the subcontractor, and so forth. So, years and years ago, the fundamental issue with construction is the payment down the line. So it's not like we're in a different world to where we were before. It's still exactly the same. So the question then is, okay, what types of insolvency exist? Because there is a misunderstanding of what they are. And there's also a misunderstanding typically on the BBC News, where they will say Carillion has gone bankrupt. Carillion doesn't go bankrupt. An individual goes bankrupt. Carillion goes into liquidation. Sorry, goes into insolvency, because it turns out they went into liquidation. So where companies are concerned, there are effectively 4 types of insolvency: administration, a company voluntary arrangement, liquidation, and an LPA receiver. I'll come on to each one, but the key one for our purposes really is administration. The reason I say it's key is because it's typically what occurs first. Almost always, a construction company will ultimately end up in liquidation, but administration is often the first port of call. Administration is a procedure under the Insolvency Act where a company may be reorganized or its assets realized with the benefit of a statutory moratorium. So what that's basically saying is, if you go into administration, you give yourself some time to work out what you can do with the company. Construction companies, unfortunately, owe so much money, and construction contracts, as we're about to come on to, say things such as, the moment you go into insolvency, no further payment is due for months and months and months. But there's no real value in the work in progress with a construction company. So it's very difficult to for someone to buy a construction company. As a retail arm, or trying to think of people who have assets, it's much easier for someone to come along because there's value in those assets. There's not much value in a construction company unless it owns lots of plant, etc., etc. So what tends to happen is there is no realistic prospect of the company being bought out by someone else. So then it moves to a second phase, which I'll come on to in a moment. Now, one of the key points with administration is it's commenced typically by a notice of intention to appoint an administrator. And the key point about that, which Sarah will come on to shortly, is that does not, under JCT or NEC, amount to insolvency. It's a pretty good sign they're about to go into one, but it's not the same as contractually being insolvent. And this can be a bit of a problem, because almost every big contractor on a construction site will initially issue a notice of intention to appoint. It will come after they've left the site, but they won't formally be in administration. Now, the notice of intention gives the proposed administrator effectively 10 days to decide whether they're going to go into administration or not. This can be extended to 20 days. And that, for want of better words, is the first breathing space, the first initial moratorium. So it gives the potential administrator 10 days typically to decide whether to go into administration, liquidation, or some other. But of course, what it means for those people with construction contracts is they're not currently insolvent during that 10-day period. So you can't take all the steps you want to on the basis that someone's insolvent until they move to the next stage. After the notice of intention to appoint, typically an administrator will be formally appointed. The system changed as to how you appoint an administrator in 2002. So most administrators now are appointed by the company itself through the directors, rather than a direct appointment from the court. So there are still a few quirks in contracts where they might need to be amended, which again Sarah will come on to make sure that you cover every base for insolvency. And as I've said earlier, administration is often a temporary pause towards liquidation, because most construction companies, it's very difficult to realize value because of the way the construction contracts are produced, and the fact that payment doesn't occur for some time. Second one is a company voluntary arrangement. Now, as it says, this is essentially an arrangement with creditors, which is a contractual type arrangement, which allows a debtor, which is the company with the problem, to pay its creditors, i.e. the parties owed money, on the basis of an arrangement. And it's a voluntary arrangement. That's why it says it. This type of arrangement is unusual with construction companies, but not unheard of. If the construction company has assets, for example, owns property or whatever, there may be a scheme that can be arranged where, provided the company is given long enough to realize those assets, it can pay off its creditors. The purpose of this talk is not to go into the finer detail of company voluntary arrangements, and quite frankly, if I did, I'd probably get it wrong. But in essence, it's a formal arrangement with creditors, and you need 75% by value of the creditors to agree the arrangement. And if 75% by value agree the arrangement, it's binding on all other creditors. Now, it doesn't take a rocket scientist to work out that if one party is owed the vast bulk of the money by that company, they have control of whether a company voluntary arrangement is going to happen or not. Now, I don't know the ins and outs of Southend Football Club, but you may have seen on the television that they are potentially going to go into insolvency. The primary creditor there is HMRC, and it's often the case that the primary creditor is HMRC. But the key point about company voluntary arrangement is it's binding on all creditors if more than 75% agree it. And these arrangements can be, you know, you'll get paid 50p in the pound, you'll get paid everything, but over a much longer period. So it's a process to be aware of, but again, not as common as perhaps the final one, sorry, wrong button, which is liquidation. And this is very much sort of the end result. This is what happens for the vast bulk of companies. For those of you who remember Haymills, Haymills went into liquidation effectively in 2010, I believe. They are still in that liquidation, so it's still ongoing. So it can take a very long time for these things to be tied up. And it's basically a process where the insolvency practitioner, someone like Nick, their job is to realize what assets they can of the company, be it work in progress, be it physical assets, distribute what that is to the people who owe the money, and that's all it's there for. There are essentially two types. There's a compulsory one and a voluntary one. I mean, again, I think it's fairly obvious. The compulsory one is where the company can't pay. The voluntary one is typically where the company is just closing itself down. And in a compulsory liquidation is typically commenced by a winding up petition. The final one is an LPA receiver. It's a fairly unusual insolvency position to find yourself in, but you could find this occurs because it typically relates to work where there is a single building, say a development job, and the SPV, the special purpose vehicle carrying out that job, has gone into insolvency. So the only asset is the property. In that case, typically an LPA receiver can be appointed, although that doesn't have to be an insolvency practitioner, and some of the ones I've been involved with have involved what you might call more employer agent type companies. And their job will be to realize the value of that asset. Typically, their job is to finish the works so the asset can be realized. It's very limited to a sort of single development only, typically. But you will come across it if you're involved, unfortunate enough to be involved in lots of insolvency issues. So they're the four types, and hopefully that gives you a bit of background on the basics. And next time the newsreader says, you know, Carillion have gone bankrupt, you can say no, they've gone into insolvency and forward one. The next question you might ask, well, okay, this will be interesting. Someone goes into insolvency, how do I get paid? If you don't know, there is essentially an order of payment of creditors. It won't come as a massive surprise to anyone that has loads of lending that the bank come first with their fixed charge. It shouldn't come as any surprise that the administrator and liquidator, i.e. Nick and his type, come second, because they're not going to do the job unless they're going to get paid. If there is no money in a company, it ends up with the official receiver, which it goes nowhere. There are then preferential creditors, and that typically includes employees who get a certain amount of money ahead of everyone else. And then you get into, there are other preferential creditors such as HMRC, there are the secured creditors such as the bank, again, ranking a slightly different place depending on the nature of their security. But then you get to the point of unsecured creditors, and that is no doubt you listening to me. As you can see, you're quite a long way down. If the bank's owed a lot of money, there isn't a great deal of money left. As an unsecured creditor, you don't get your money until the lot at the top have got theirs. And having a court judgment against someone does not mean you are a secured creditor. You have to have some kind of security by means of a charge, such as a fixed charge or floating charge, to get higher up that list. So you often hear people say, well, I've got a county court judgment. It doesn't make any difference. You're still an unsecured creditor at that point. So just to sort of make sure people understand that. So what's the standard position? Very briefly. So what typically happens is if a large contractor goes bust, typically happens is they issue a notice of intention to appoint an administrator. So there's a 10-day pause. There's this hiatus about what happens on site. Some subcontractors still keep working, some don't. At a certain point within that 10-day period, there will typically be an administrator appointed. And you can have this bizarre situation where people are still working, even though the company's insolvent. At the point in time that an administrator is appointed, both under JCT and NEC, the contents of the contract tend to kick in. And at any point within 0 to 12 months, let's say typically a couple of months later, it will get converted into a liquidation. So what you need to be thinking about here is what's going on with the materials, which we'll come on to. When and how are you going to start working with your new contractor? If you're owed money and you're a subcontractor, is there a way to get your money back? Have you got credit insurance? Can you use that credit insurance? For the smaller companies, your typical subcontractor, and a smaller subcontractor at that, they often go straight to liquidation because they're not so central to a particular job, and all of a sudden they're just not there. So you might get informed by a liquidator that someone's gone into liquidation. You might be owed money, therefore that's how you get informed. There'll be a creditors meeting. You might be asked to put in a proof of debt. It's all very slow. And at some point you'll be told how much money you're getting in as a proportion of what you're owed, and often it's nothing in the bank. So that's a fairly standard thing. I'm going to come on to later a couple of more better examples of what happens and stuff. But again, if you are owed money, you may have the benefit of credit insurance, which will give you the opportunity to continue to recover it. I'm now going to click you on to Sarah. And that should work seamlessly.
Good afternoon, everyone. Thanks, Andrew. So I'm going to spend a bit of time talking about the standard form subcontracts and how those deal with insolvency. We're going to focus on the two most widely used forms of contract, which are, of course, JCT and NEC, which I'm sure you are all very familiar with. So firstly, JCT. So under a JCT main contract, in all of the key contracts, so we're talking about design and build, standard form, intermediate, they define insolvency in the termination section, which is at section 8. As you can see on the slides, a company is considered insolvent when it enters into administration, when an administrative receiver has been appointed, on the passing of resolution of voluntary winding up, or on the making of a winding up order, or where a CVA has been entered into. So basically all of the things that Andrew's just spoken about. As Andrew did already point out, notice of intention to appoint an administrator, which is very often the first step in an insolvency, is an insolvency for the purposes of the JCT definition. This is a fairly significant point, and we're going to discuss that a little bit more in a moment. Just briefly, for a partnership, the relevant trigger is the making up of a winding up order, and for an individual, it's the making of a bankruptcy order. Just briefly, it's probably worth us mentioning the Corporate Insolvency and Governance Act 2020, which was a piece of legislation that was introduced during and really as a response to the COVID-19 pandemic. Under that act, there were two new insolvency measures that were introduced. Some parts of that act were temporary, but these two measures are actually permanent. They're both applicable to companies, and they are a statutory moratorium, which is under Part A1 of the Act, and there's also a restructuring plan procedure, which is Part 26A. The reason for mentioning it here is that neither of these are likely to be covered by the current definition of insolvency under the JCT and indeed under the NEC contract. So as you can see with the notice of the intention to appoint and other formal insolvency measures, even where there are formal measures, the contract may not consider that to be insolvency. So why does this all matter? So under clause 8.5.1 of the JCT contract, the employer is entitled to terminate the contractor's employment at any time by giving notice if the contractor is insolvent. So clearly that means insolvent as defined under that contract. It's worth noting that unlike other rights to terminate under the JCT contract, which as I'm sure you're all very aware, it requires two notices. Insolvency only requires one notice to be given to the contractor. Another important point to note, as it says up on the slides, there's no right to terminate for insolvency at common law. So if there isn't a specific contractual right, insolvency itself isn't considered to be a breach of contract. This essentially means that if you want to terminate for insolvency, the insolvent party has to be insolvent as defined under the contract. If you're including within your contracts, as is very, very often the case, particularly at the moment, a requirement that the contractor procures a bond, a performance bond, it's worth remembering that the ABI form of bond, which is the one that's very widely used in the construction industry, mainly because it's accepted by most sureties, it doesn't actually deal with insolvency. The bond is triggered on a breach of the underlying contract, and because insolvency isn't a breach of contract, the contractor's insolvency alone won't trigger the bond. You'd have to wait until there was a different type of breach. So far we've concentrated on insolvency and the rights to terminate, but it is quite important to remember that under JCT it isn't actually all about termination. It's a relatively common misconception that in order for the employer's rights to arise on an insolvency, that the contract's got to first be terminated. But clause 8.5.3, the relevant part is up on the slide there, makes it clear that these rights apply from the date that the contractor is insolvent, and that's whether or not the employer has given a notice of termination. So there doesn't actually have to be a termination under JCT. So what happens on insolvency under JCT? Well, the contract tells us firstly that clauses 8.7.3 and 8.7.5 apply. We'll look at those in a little bit more detail just on the next slide. Not surprisingly, the contractor isn't any longer required to carry out the works. It may be very likely that they're not in any position to do that anyway. And finally, the employer is entitled to secure the site. Now, this is where things often get a little bit tricky, and I'm sure you've experienced this if you've been involved in a project where the contractor has become insolvent. Subcontractors and suppliers are often not very keen on leaving their materials on site. In fact, quite the opposite, they will actively try and remove them, likely because they may not have been paid for those materials. Regardless of what those subcontractors and suppliers have agreed with the contractor, so they might say that they have retention of title clauses in their subcontracts or supply agreements, it's a slightly complicated area of law, but it's very likely that the employer will have good title to the materials that are on site. So it's always a very good thing for the employer to, as a sort of a very early step, if there is insolvency, to secure the site to prevent materials from disappearing. So just coming back to clauses 8.7.3 to 8.7.5 that we just mentioned, these are the clauses that deal with the payments that are due following insolvency. So firstly, the JCT contract makes it clear that no further sums are due to an insolvent contractor. The clauses relating to whether or not a pay less notice must be issued, that's clause 8.7.3, are not abundantly clear. But basically the rule is that if a payment has already been certified, a pay less notice should be issued in the usual way. If the employer can't issue a pay less notice because the last date for issuing a pay less notice has passed by the time that the contractor's insolvent, a pay less notice isn't required. I've put the case Melville Dundas on the slide there. In this case, the court considered the interaction between insolvency legislation and the Construction Act, and basically decided that the Insolvency Act trumps the Construction Act. So it may not be strictly necessary to issue a pay less notice at all, but our advice would always be to follow the contract and issue a notice if it is possible in the timescales. It just avoids any arguments later down the line. 8.7.4 and 8.7.5 deal with final account. The position under JCT is that the final account isn't prepared until after completion of the entirety of the works, and then completion of the defects, and then a further 3 months. So basically, when the financial position is known by the employer. Clause 8.7.5 anticipates that sums might be payable to the contractor, but it's highly unlikely that this would be the case once all of the costs due to the employer have been assessed. And essentially, it's a calculation of the sums that the sums due to the contractor for the works that have been carried out, less all costs that are due to the employer as a result of the insolvency. Hence, it's unlikely to be a cost due to the contractor. So moving on to NEC 4 and the definition of insolvency. So essentially, it's very similar to the JCT contract. The NEC definition is set out in the termination section, as with the JCT contract. It's dealt with under clause 91.1. I've put the definition up on the slide. I'm not going to read through it because, as you can see, the definition under NEC is very similar to the JCT contract. The key point, once again, and it's something I know that we're both repeating ourselves a little bit here, but it is an important one. The notice to appoint an administrator is not an insolvency event for NEC. So the client's rights on insolvency, unlike the JCT contract, the client's rights where the contractor is insolvent flow from the termination. There aren't separate, distinct rights when the contractor is insolvent. So until the project manager has issued a termination certificate, the client's rights on insolvency will not have arisen. The NEC contract applies different procedures on termination and different methods for the assessment of an amount due, depending on the reason for the termination. Termination on insolvency will entitle the client to procedure P1, P2 and P3 and amounts A1 and A3. Whilst that all sounds very complicated, in essence it is very similar to the JCT approach. So as with the JCT contract, the client is able to engage others to complete the works, use plant and material which it has title to, and to ask the contractor to stop the works and to leave site. the client, not like JCT actually, but the client also has the ability to instruct the contractor to assign the benefit of any subcontracts or supply agreements. This may or may not be helpful in practice, because obviously that is dependent on the contractor actually having the ability to sign those underlying subcontracts and agreements themselves. So consequences of insolvency, payment provisions. As with the JCT contract, the contractor is entitled to be paid for works properly carried out up to the date of the termination. How this is assessed will depend on the pricing option applicable to the contracts, but essentially it's the works carried out up to the date of termination. The key and very important difference between the NEC approach and the JCT approach is that rather than waiting until all the works are completed and actual costs are known, the project manager is actually required to make a prediction of the amount that they will assess will be the likely cost to the client of completing the works. So it's a forecast final account essentially. This forecast has to be certified within 13 weeks of the termination, and depending on the stage of the project, that could be significantly in advance of when actual costs are known. The value of the forecast will be something that will need to be very carefully considered by the project manager, because everyone will want to avoid a situation where the cost of the final works have been undervalued and the client's obliged to pay an insolvent contractor. It's not something that's likely to make you, as project managers, very popular with your clients for obvious reasons. So what does this all mean? Well, basically, if a contractor goes into insolvency, the employer is really the one that holds all the cards, quite rightly so, you may say, mainly because there is no longer an obligation to have to pay the contractor, and the employer is entitled to dictate whether or not those works are to continue. And obviously the employer also has all of the rights over the plant, equipment and materials that are on site. So just having a look now at what you should do in the event of insolvency. So we've just spent some time talking about how the standard form contracts deal with insolvency, but as Andrew mentioned earlier, there is inevitably a period of time where it's quite clear to everyone involved that in the project that the contractor is heading towards an insolvency before they're actually insolvent for the purposes of the building contracts. So some of the common warning signs, and they're probably fairly obvious, but we've put a few of the key ones on the slide. So firstly, it might be that contractors' employees or subcontractors stop coming to site. There will probably be a general slowing down in progress of the works. There's likely to be some rumours flying around about the contractor's solvency, and that's likely to be the case if members of the supply chain haven't been paid. Tend to hear about that relatively quickly. It's obviously very important to be aware of all of these indicators, but the very key point here is that none of these things alone will amount to the contractor being insolvent for the purposes of the contract. So all of the rights available to the employer that we've just discussed under the various building contracts for dealing with insolvency won't have arisen. So what do you do in this strange sort of interim period? Well, it probably goes without saying, but no one is going to thank an employer's agent or a PM who pays a contractor for things that aren't strictly payable if the contractor then shortly after becomes insolvent. Now, clearly, until the right to stop paying under the contract has arisen, the employer is still obliged to pay the contractor for work that they've properly carried out, so that they don't fall foul of the Construction Act. So just not paying isn't an option. But it is sort of relatively often the case that interim valuations aren't necessarily valued strictly in accordance with the contract. Some sort of obvious examples are, JCT and NEC don't allow for on-account payments. They don't allow for payment of materials that are prematurely on site unless that's specifically been agreed. So basically, the key message is only pay for things if you absolutely have to, in accordance with the contracts. If an interim payment has already been certified, there's of course always the option to revisit that interim payment and issue a pay less notice. Also, if there are any outstanding subcontractor collateral warranties, it would be really sensible to make sure that they're completed as soon as possible, because that will give the employer a direct contractual link to subcontractors, and also potentially the right for the employer to step into the underlying subcontract. So how is it best to protect your position where there is an insolvency? Well, firstly, you need to ascertain whether or not the subcontractor or the contractor is actually insolvent for the purposes of the building contract. If they are, and if the contract allows it, which JCT and NEC do, don't pay them. The next step is to take measures to secure plant and machinery. Always review payment obligations to subcontractors, professional consultants, suppliers. It might be that you have got the ability to assign or to agree to a novation of the contract, or to agree new contracts with those subcontractors and suppliers. People often think that, you know, if a party's insolvent, the contract has got to immediately be terminated, but that's not necessarily the case, and it's important to explore all options before taking that step, because it is quite a major step. Depending on the progress of the works, it might, you know, if the works are almost complete, it might be better to omit certain elements from the contractor, agree direct payments to the supply chain, something along those lines. If there are outstanding collateral warranties from subcontractors, it would be a good idea to get those finalised pretty quickly. And finally, as with everything, knowledge is power. So make sure that you are monitoring any insolvency proceedings as they develop, because things can change, as Andrew mentioned earlier. So final slide from me, being a non-contentious construction lawyer, I couldn't really get through a presentation without talking about amendments to a building contract. So whilst it's clear that the employer really does hold all of the cards where there's a contractor insolvency, there are still some amendments that could be made, and probably would be very sensible to make to protect the employer's position. The best way, the most important way to do this would be to widen the definition of insolvency. The main thing, you're not going to be surprised to hear, would be to include the notice of the intention to appoint an administrator as an insolvency event. It would also be sensible to include the statutory moratorium and the restructuring plan under the new corporate insolvency legislation, so that's brought within the definition. You could go one step further. You could try a clause similar to the one up on the slide. So where there's even the suspicion of an insolvency, you would be entitled to the various options as if the party was insolvent. Obviously, quite how easy it is to show a reasonable belief of insolvency will be open to interpretation. If you're dealing with the NEC contracts, it would be very wise to amend clause 53.1, making the period for the final assessment significantly longer than 13 weeks, or even better, link it to a period of time after the completion of the defects. And then finally, just coming back to the performance bond point, if you've got a requirement in your contract that the contractor provides a performance bond, make sure it's one that includes insolvency expressly as a trigger to the bond. I'll pass you back on to Andrew.
Back again. Slightly conscious of time, so I'll try and skip through this. For those of you who like all the case law, you've probably seen lots of case law about insolvency and can you adjudicate. The issue here is there's a fundamental problem with paying someone on an adjudication when it's only a temporary decision, where if that company is insolvent, you can't recover it following a court case. So there's lots and lots of case law on this, and I'm just going to very briefly touch on it. The main point is, as it says at the bottom of that slide, an insolvent company can adjudicate, full stop. You cannot run an argument that an insolvent company can't bring an adjudication. The Bresco and Lonsdale case says that. I won't go into it in any detail. The primary point, as said by the judge, again, if you look at essentially the bottom sentence, the court is not going to override a statutory right, and there is a statutory right for any party to bring an insolvency at any time, bring an adjudication at any time, whether they're insolvent or not. So that's the starting point, that an insolvent company can adjudicate. However, we then get to John Doyle. John Doyle, which went to the Court of Appeal, consisted of a dispute relating to the Olympic Park. So it shows how long these things can take, because obviously that was 2011, probably when that was done, 2012. You have this sort of bizarre scenario that years later an adjudication is commenced, and John Doyle, who were the sort of subcontractor, were awarded 1.2 million. So the question is, were they entitled to be paid that? In light of the fact they're insolvent, and so if they were paid that, there'd be no means of ever getting it back if they then had a full-blown court case. For those of you that follow this, Lord Justice Coulson was in the Court of Appeal, and he made the point that this is an interrelation between construction law, insolvency, and adjudication. As we've heard already from Melville Dundas, the courts will put insolvency effectively ahead of adjudication. And without saying too much more, John Doyle basically says it's, yes, you can adjudicate if you want, yes, you can get a decision, but the chance of you being paid it is very slim. So it's still possible to do it, but you know, what John Doyle has done is made it very difficult. This last slide actually has a picture of Pythagoras. For anyone involved in this, there is a company called Pythagoras who is the sort of champion of bringing adjudications for insolvent companies. There's nothing fundamentally wrong with that, but they're struggling to get paid because of John Doyle. And as one very recent example, J.A. Ball and St. Philip's Homes, exactly the same thing. And the judge said, well, I'm not going to make the other side pay. I'm going to stay the payment, let the other side have it decide properly in court proceedings. So the underlying message is, yes, a party can adjudicate if they're insolvent. Can they get the money? Very unlikely. Before I pass over to Nick, just very briefly how it actually works from our perspective. This is what happens all the time. This is a classic example. You hear rumours the contractor's in trouble, progress has slowed down. The directors have a meeting and say, no, it's all fine. 2 weeks later, you get a phone call saying tomorrow the site's closing, we're going into insolvency. They don't actually go into insolvency straight away. They have a notice of intention to appoint an administrator, as we've discussed. The client is busy talking to the subcontractors. Sometimes the clients pay them direct. The clients say, yeah, one of these is going to act as the main contractor. It's going to be seamless. We aren't going to lose any time. There'll be no delay. Leave it with us. We don't need any legal advice. Okay, great. Then what happens is the subcontractors actually don't play ball. They want to be paid what they're owed by the contractor. The person they thought was going to take over the works won't take it over it. Any payments made to subcontractors are arguably, they're fine, but you still have to pay the contractor the same amount of money. And the message is calm down. If someone goes into insolvency, there's going to be a delay. It's not going to be that long. It's not going to be, you know, ultimately it should be fine, but you need to calm down. What you need to do, as Sarah's already said, protect your position with a pay less notice. Wait until they're formally insolvent. Deal with the fact suppliers are going to get strong. The problem for suppliers is they don't own the goods in most cases. Understand what's actually going on site. Discuss with a sensible new contractor, not another one who's going to go bust straight away. Work with key subcontractors and professionals and expect a couple of months delay, because that is what is likely to happen. And going forward, you know, we've already said you don't pay any more money. You can use the materials. Typically, you want to be taking over the scaffolding because you don't want that to come down and go back up again. You do need to allow individuals' personal plant and hire plant to be returned, and just have a clear view. But don't panic, but don't think it's going to get sorted overnight. I'm just now going to pass you on to Nick, who is at a firm called Parker Andrews, and hopefully, Nick, you are there. There you are.
I am. Hi, Andrew. Hi, everyone.
If I put
Thanks
Nick on his
for
first slide, he can take it from there.
excellent. Thank you for that, Andrew. Thank you, Sarah. What I'm going to take you through is just maybe a little quick 5 minutes about how I would look at something on the practical basis when I'm walking into a situation where there's a company that's insolvent and I'm advising it about what to do. Just to give you a little bit of background about my sort of history and how I got involved in the industry. So I'm a licensed insolvency practitioner. I've been in the industry over 20 years or so. I appreciate it's a fairly specialised area, both of law and sort of practicalities about what happens and how it works. So on the very base level, I am effectively licensed to act and advise companies and individuals, specifically around those that are in financial distress, and that can involve directors of companies, but it's mostly corporate entities that I will advise. I am from an accountancy background, and most IPs are. There will be some with legal background as well. And we typically will work, those of us that take appointments as administrators and liquidators will operate in either sort of branches of accountancy firms or in boutique practices. There's a trend within the industry to move towards boutique firms. You may have seen creation of split away from big four firms into separate sort of advisory firms. I am licensed by the Institute of Chartered Accountants in England and Wales, and I hold a license. To get that, I have to pass an exam called the JIEB, which is a thorough practical examination of the skills about going on site and dealing with situations with construction clients, like some of the examples you may have seen already in the presentation. I am inspected and reviewed on a yearly basis. I have external inspections at least once every 3 years, and that goes through all of my files and workings, probably very similar to the SRA, as Andrew will no doubt a bit of experience. And there's roughly around 1,800 IPs that take appointments in the country. There are many more that are qualified as insolvency practitioners, but I'm sure you can appreciate with that sort of few numbers versus the amount of insolvencies that there'll be year on year, we're quite well placed that we see a lot of construction insolvencies and a lot of stories across the economy as a whole, and that's why I'm going to go through a few of the practicalities and what my job is. Next slide, please.
Sorry, that's my fault.
Yeah.
And I've got to find where the mouse is. There we go.
Okay. So my job as an IP is to, in effect, when it comes to advising the board, placing it into some form of procedure, when that changes from a rescue situation to being appointed into an administrator or a liquidator, my role is to effectively enhance and improve returns to all classes of creditors. Effectively, the way it works is I try to maximize returns, maximize value from the assets or the business, and then distribute that in the order of the creditors as it's prescribed by the Insolvency Act. Now, that is quite a peculiar how it all works in terms of distribution. I don't propose to go into any further detail, but I'm sure you can appreciate there are many competing interests, many various stakeholders, depending on the type of business, the size of the business, and the profession that we're talking about. That's the kind of spectrum that I tend to be involved in. There will be also stuff that will be about rescuing the business as going concern, which I'll talk about briefly in a minute. But then the question, next slide please, is why is it all relevant? Why we're talking about all of this? Well, you only have to see the statistics here from the Insolvency Service to show you about the numbers of insolvencies in the country and how they're rapidly increasing. Even the R3 president, which is the trade body to which I belong, has already said that this 2022 is the year that the insolvency dam burst. For those of you that may remember back to the credit crunch times in 2008, which is the latest spike you can see in that graph, that was when 15 years ago, what effectively happened was it became almost a little bit more political and a little bit more problematic to winding up companies. And we've had a prolonged period of companies that have really survived on sort of very low interest rates, as we all know, and how they're increasing. Effectively, the combined effects of the credit crunch morphing into what is now the cost of living crisis and COVID is spiking insolvencies, and they're kicking up through the roof. You can see already that 1 in 202 companies is actively going into liquidation, has done in 2022. I expect that number to increase within 2023. The specific reference and particular point of concern for you as members of the construction industry, next slide please, is when we then look at those stats and extrapolate them out into how that works into various sectors of the economy, and that spike can be particularly pronounced within construction. You will see here within those numbers that that's already, in terms of a bellwether, as we've already mentioned with Andrew, it tends to be a bit of a marker as to the performance of the economy, as to where the construction insolvencies are. However, this is now a particularly sharp curve pointing very upwards, and I could expect it to continue in that fashion from 2022 up to 2023. That therefore leads to I'm expecting to be busy, and I'm continuing to be busy within the construction industry, advising clients on a regular basis of various sizes, from small subcontractors all up to multi-million pound turnover businesses. So without further ado, what am I doing? How do I advise clients what to do in circumstances, and how do I organize all of this? Because we've already seen the circumstances and the issues that I would probably encounter with JCT and AC contracts on recovering and rescuing businesses that have fairly stringent and tight insolvency clauses within the contracts. Next slide, please. So I, as an insolvency practitioner, I have a requirement, as I mentioned before, to improve returns and realizations. And there is also a hierarchy of light touch to heavy touch in the work that I do. So unfortunately, the nature of the job of what I do is I do not know the situation of the business until I walk in on day one. And so I can tell you about all the hypothetical situations and all the situations I would like to do. However, I, by design, do not know the company's history. I do not know the relationship it has with its clients. And then equally, I do not know how far gone they are in terms of removal from site, or trading on, or issues they've had in terms of materials, subcontractors, payments to them all, as have all been highlighted already in the presentation. So my first intention and plan is always to show how can we trade on, how can we rescue the business as a going concern. Obviously, when we're talking about administrations as being the primary tool here, the notice of intention is a practical tool that I can use to effectively bring about a moratorium. The moratorium allows me to suspend any legal action being taken against the company for enforcement of debts. So particularly where companies may have some revenue issue or debts being pursued in terms of winding up petitions or threats of them, the administration allows that breathing space to take place and have a true approximation and evaluation of the business and its performance. In a perfect world, we would like to, in those circumstances, trade on, continue to working on site. However, that's not often practical. Normally, in these situations, we look to review the works and see what could be completed before any insolvency procedure is initiated. 9 times out of 10, however, that's going to require some negotiation with the main client, the main employer, to actually finish off those works, because as you've already seen in the contracts, particularly when they're worded correctly, they hold all the keys. So ultimately, there is a practical negotiation procedure that will need to be undertaken on both sides through whatever mechanism to be able to works to be completed. Now, this isn't necessarily something that's prescribed in law in terms of the contract, but the reality of this situation is I have a contract, or as a, say, an administrator or prospective administrator, you have a site that needs to get finished off. You will need to make that evaluation as to whether the cost to get a main subcontractor or someone else in to finish off the works is worth it compared to paying the administrator, or seeing if the administrator has any aptitude or wherewithal to finish those works off. And that is on a case-by-case basis, and that's something that would have to go on depending on, even on contract-by-contract basis. One other option I have in those circumstances would be to arrange or try and negotiate a sale of the business. Now, that can either sometimes be back to the directors, or to a third party, or even to a subcontractor. Now, there are very prescribed manners and ways in which I can do that. I'm sure people have already heard horror stories of phoenixing and the bad name that comes with. We do that through a thing called SIP 16, which is through a real sort of proper valuation, arm's length transaction. That is then opened out to tender and to valuation so that anyone can bid on that. That is one mechanism that some way gets around the contractual issue. However, the terms in that, we still come back to the point of negotiation that you're going to still have to need to negotiate with those clients and have that sort of organisation there. We then go down the more sort of draconian and desperate sort of means, really, because once companies are getting kicked off site, there's very little that I can do other than to really get agents in, get QSs in to try and negotiate and recover what monies are due. And that then goes back to your latent defects periods, the terms within final accounting, and trying to really negotiate in terms of recovering all of that debt. Some of the times when I've been instructed and the company's already been removed from site, there's not much I can do other than sit and wait, and a lot of that would depend on the strength of those contracts. At which point it simply for me becomes a sort of a recovery exercise in terms of trying to recover what I can to improve the return to the company's creditors. And all of those options and all of those sort of bits of information really dictate as to what procedure from the Insolvency Act I'm likely to instruct or seek an appointment on. The administration tool is great, however, it is more expensive, and therefore if it's actually going to not produce a better return or in some ways allow me to do more work for the benefit of creditors, then there is little need for that, and it may well just be a simple liquidation that is required. Hopefully that's given you sort of a little 5 minutes sort of brief as to what my options are, what I look at doing, and why it's particularly relevant at this time in 2023.
Okay, thanks very much, Nick. I don't know if we're going to get Sarah. There we go. I've got a couple of questions well, one initially for Nick, which as we talked about earlier, the line's going upwards. Presumably it doesn't go straight back downwards again. And it seems almost as high as 2009. From our experience, we found that there are certain types of contractors, certain sizes of contractors that tend to be going bust. They tend to be a certain size, seem to be into a certain size contract. Are you seeing any trends at all, or is it just lots of people?
We're generally busy across the board, but there tends to be a particular pinch point in the minute, sort of north of £10 million turnover. I don't know if you've seen that yourself as well, where it tends to be companies with employees that are main contractors on sites and really feeling sort of being squeezed in the middle. Insolvencies are going up across the board, but we're seeing a pronounced spike within construction, as you've already noted, and I would expect that to continue throughout the year. I'm starting to see some telltale signs of what would be recessionary behaviour. So I briefly touched on construction being a sort of a little bit of a taste for how the economy is performing as a whole. I'm also seeing other people in other sectors sort of withdrawing capital, which is another marker that we normally look at as to seeing how the economy is performing. However, that's not really coming out in the data in terms of the GDP and how the economy is performing just yet. So it's strange times, but we're definitely getting more busy.
Yeah, I mean, the type of contractor we're seeing go into insolvency tends to be between, say, 20 and 50, maybe 75 million type of contractor. And the ones I had on the initial list, they tolerant look quite a bit bigger, but they're the ones who are doing £6-7 million jobs, maybe 6 or 7 of these a year, and they've been very hit by the material price change, labour shortage. They can't spread it across lots of jobs, and they have quite aggressive completion dates, liquidated damages. That's that type of contractor that we're seeing is the one that, as you say, they tend to be not the smaller contractors, and certainly not the bigger ones. They ride out these waves, albeit Korea might be an example. There may be another one, but so that does seem to be the issue. We're nearly out of time. One thing I was just going to say is It's often frustrating to work out what's going on with a company. There are options. There's something called CE filing on the High Court that I would recommend people register for, because that gives you the ability to check a company, and it tends to be a way to find out what's going on quicker than on the Gazette, or certainly on Companies House. If you are aware of an administrator appointed, you should call them, because they're perfectly willing to talk to people. That's not their job to be difficult. In fact, it's their job to talk to creditors and stuff. So just be aware that it can be quite frustrating. I think we'll call it a day there, because I'm conscious we've just gone over. Yeah, I should have said at the start, despite Heather telling me expressly to say it, I didn't. There's a copy of the slides will be available after the talk, so hopefully she'll let me know. And thanks very much for your attendance, and hopefully, you know, if you've got any questions, obviously fire them through. And thank you, Nick, for giving us a slightly different flavour as to what the whole insolvency practitioner does at the end of it. So, all right, hopefully that's okay. And I think Heather will probably just cut us off. So thanks very much.
Thank you.